much. This scrutiny period is clearly our main chance to secure reforms in Vietnam. After the ratification, we know from our experience of other trade deals that the power of the European Parliament changes. We can still put pressure, but we don't have the same leverage. And therefore, I think we have to use the next few months very, very carefully, and we have to be very strategic in what we're asking for. And we have to make sure that a European values-based trade policy is values-based in action as well as in words, because otherwise we lack credibility, I think. And those high expectations of the people in Vietnam are because we are sending out a signal to the world saying we have a values-based trade policy. If that comes down to mean nothing, then we actually undermine our credibility in general. That's all the more important because I reiterate that last week in Hanoi, we heard consistently from a number of different meetings that the human rights situation is deteriorating. It's very difficult for people, especially in terms of freedom of expression, and particularly in terms of online freedom of expression. That was very, very clearly set out, and that's why I think that we have to boost the report drafted by the rapporteur in relation to human rights, because at the moment it's far too weak. There's far too little in the draft report on human rights. We have to reiterate some of the demands that we've made as a European Parliament in 5 resolutions since 2013, and particularly in the context that 18 major human rights networks this week published their evaluation of Vietnam, largely setting out the same concerns that the European Parliament has consistently set out in those resolutions. So it would be very strange if we didn't make those same demands now in the ratification process. But equally, I recognise that last week I think we heard a genuine will to engage from the Vietnamese authorities. We were extremely clear in our demands in every meeting, demands in terms of labour rights, human rights more generally, and cyber security. So I will be focusing my amendments on those 3 areas. I think on labour code and labour law reform, we need to have the labour code adopted before it comes to the votes in the European Parliament. And within that labour code, we need to have the principles of ILO 87 and ILO 105 included in the labour code, alongside a credible roadmap for the ratification of the last 2 ILO conventions. And we also need to have a commitment for the engagement of the European Parliament in the implementing measures, 10 implementing pieces of legislation, it seems. On human rights, I've already set that out. We have a clear position from the European Parliament. We should reiterate it. On cyber security law, it's clear that there's an ongoing dialogue. I think it would be extremely important that we have clear signals from the Vietnamese authorities before we vote about the implementing legislation and about changes to the direction of that legislation to protect fundamental human rights. So I come back. We have a short period where we can really apply leverage. We need to use that period very strategically. On these 3 areas, we've raised those concerns in Vietnam. I hope those concerns have been heard in Vietnam, and my group will decide our voting position in accordance with whether we see progress on those 3 concerns. It was very clear last week investment flows have been very important for Vietnam's economic development. We heard it throughout the visit. And clearly people investing have an expectation that they won't have their property unfairly removed or without compensation. However, we know from UNCTAD that there are different ways to ensure investor protection. And the rapporteur's draft report states that ICS will automatically boost job-creating investments. This is, I would argue, wishful thinking. When I asked the Commission in the last meeting for evidence of a direct connection between ISDS and investment flows, they didn't reply to the question, partly because the evidence suggests that there isn't a direct causal link between ISDS and FDI flows. 8 EU countries at the moment have no ISDS with Vietnam, despite substantial FDI flows in that direction. And while investors want ISDS or ICS, they don't necessarily actually need it. I think fundamentally the question is about fairness in front of the law. And the draft report welcomes the fact that EU companies will not be discriminated compared to Vietnamese companies. But that misses the point that ICS actually discriminates in favour of transnational corporations by creating a separate legal system for them. Whilst their interests are defended there, the interests of environmentalists, workers, human rights activists depend on the legal system of Vietnam, even in cases where they're subject to violations as a result of international investors and multinationals. So without substantive obligations on investors included in an investment agreement, there is very little balance in the European system as it stems, and there's little incentive for multinationals to engage in what they should be doing, which is judicial reform inside Vietnam to improve the Vietnamese judicial system, which would benefit international investors and local activists defending their communities and their rights.